Assalamualaikum and a very good morning I be to our beloved lecturer, Madam Noor Ashikin Binti Hamid and my fellow friends. My name is Muhammad Farid Zakwan and together with me are Nazatul Husna binti Nazri, Nurin Hidayah binti Muhammad Hadi, Teh Ziangrong from Group 12 for Administrative Law. Foremost, we would like to introduce our case study presentation in which the question given is analyze some of the characteristics of the Ombudsman gleaned from the above statement and its practicability to be implemented in Malaysia. In this video, we will explain to the audience regarding our introduction, materials and methods, the results and discussion in which our main discussion here consists of the functions of Ombudsman, the characteristic of Ombudsman, and the practicability of Ombudsman in Malaysia, and lastly, conclusion. First thing first, we introduce our write-up by providing the concept whereby the maladministration is a political term which describes the actions of a government body which can be seen as causing an injustice. The term maladministration may include corruption, bias, unfair discrimination, faulty procedure, harshness, misleading a member of the public as to his rights. A person complaining of any personal injury suffered by him by administrative action can send complaints to the Ombudsman not directly but through a member of the House of Commons. The House of Commons has set up a select committee to consider the Ombudsman and the officials of the department which he criticized. Occasionally, the special reports made by the Ombudsman have been debated on the floor of the House. By referring in the case of Parliamentary Commissioner for Administration ex parte Daya, the court has laid down the following propositions as regards to the functioning of the British Ombudsman, which are first, he is susceptible to judicial review, but the court will not readily be persuaded to interfere with his discretionary powers, given their weight and high degree of subjective judgment involved. Secondly, he is entitled to limit the scope of his investigation by choosing one of a number of complaints to investigation. Thirdly, he is not required to hand over a copy of the draft investigation report to the complainant for his comments. And fourthly, once he sends his report after investigating a complaint to the sponsoring member of parliament, he becomes functus officio and therefore cannot reopen the complaint. Furthermore, the formation of Ombudsman Malaysia, which is set to replace the Public Complaints Bureau, PCB, will result in greater transparency and accountability as the country moves into the era of a new Malaysia, whereby it was set up in 1971 under the Prime Minister's Department and has two main objectives, namely to bring about the closer rapport between the government and the public and to establish a channel enabling the public to put forward their complaints in connection in government administration or service or complaints on federal administrative action deemed unjust. The PCB has grown from time to time. It gave the opportunity to the public to complain of their dissatisfaction against all aspects of administration of the government except any issues that have been determined as the policy and underlying principles of the government. However, its functioning depends entirely on the cooperation of the various government departments and agencies. In other countries like New Zealand, United Kingdom, and Mauritius, they have the system that closest to PCB that practiced in Malaysia, known as Ombudsman, which has better features. An Ombudsman can be defined as a government appointee who investigates complaints by private persons against the government. The term ombudsman is Scandinavian in origin and broadly means a grievance or complaints officer. Furthermore, ombudsman, also known as a body that created by statute, independent from the government and impartial in their dealings with complainants and those complaints about. They exist to consider complaints by citizens that public organizations have caused them injustice by maladministration. Moreover, this study used a qualitative method to examine and address the characteristics of ombudsman and on its practicability to be implemented in Malaysia. The data collected for research is mainly derived from printed documents, which are considered as reliable sources. The first group of printed documents, considered primary data, was collected from international sources such as the International Bar Association and confidentiality in federal dispute resolution programs. Examples of acts and provisions referred to were the Section 2 of the International Ombudsman Association Standards of Practice, Code of Ethics, Ombudsman Act, and Official Secrets Act 1972. The second group of printed documents is considered secondary data gathered from academic literature such as books, journals, newspapers, articles, and reports and conference proceedings. Hence, the materials include the articles regarding the characteristics of the ombudsman gleaned from the above statement.
Next, we continue with the function of ombudsman. According to the statement by Ahmad Faiz Yaakob, the ombudsman is an autonomous agency with the authority to investigate any misconduct or abuse made by the government towards public members. More precisely, the ombudsman operates as a watchdog which concerns legal protection of individual citizens with regards to conduct of public authorities. The primary functions of ombudsmen is to collect and review complaints against public authority which receive from the public members and recommend redress when it is required to do so. The ombudsman acts as guardian of quality performance in identifying the fundamental weakness in the government structure. Next, ombudsmen act as supplement to the government's legal protections. Ombudsmen may also be addressed with complaint cases in which these may not be settled by a court of law. Under such circumstances, an ombudsman serves as mediator between the complaining citizen and the public body or civil servants concerned. The ombudsman's recommendation is non-binding as it is not an administrative judge, and the public body may refuse to implement it. Nonetheless, an ombudsman may give evaluation of the lawfulness and the ethical nature of the conduct of the administration. The findings of such an ombudsman's inquiry may be used as evidence in court proceedings, but they may also be used for the development of an organization. Next, we continue with the characteristic of ombudsman. The parliamentary ombudsman is referred to as the classical ombudsman model, which constitutes the conceptual point of departure to indicate the fundamental characteristic of ombudsman. First characteristic of ombudsman is independent. Notably, the crucial role of ombudsman is to deal with administrative conflicts. The concept is focused on the principle that people are entitled to inquire, to complain regarding specific actions by authorities, and that their grievances should be investigated independently. The ombudsmen are established by the Constitution or law in order to defend against specific acts made by public authorities. Ombudsman is a separate body or independent from public authorities and in fact, by jurisdiction, has the authority to review complaints and to make recommendations. They also may act on their own motion and have the authority to prosecute. It is difficult for others to control the ombudsman as it is an independent agency.
The second characteristic of ombudsman is confidentiality. There shall not on a mutual basis report to someone outside the office of the ombudsman any sensitive details given by the individual or the name of the person as it may cause harm unless specifically allowed to do so. In regards to what type of confidential information should be protected can be referred to the guidance entitled Confidentiality in Federal Dispute Resolution Programs at 65 FR 83085, 29 December 2000, which stated that the applicant may require that their identity such as name, business, or organization should be kept confidential, or all of the complaints made specifically must be kept in confidential. The ombudsman must have the approval by the complainants before they started to deal with any direct action. The third characteristic of ombudsman is impartial and fairness. Section 2.2 of the International Ombudsman Association Standards of Practice stated that the ombudsman strives for impartiality, fairness and objectivity in the treatment of people and the consideration of issue. The Ombudsman advocates for fair and equitably administered process and does not advocate on behalf of any individual within the organization. Significantly, the Ombudsman is not involved in any situation that could establish a conflict of interest. In order to make it open to complainants from every political party, the Ombudsman qualifications are established in order to choose an individual universally regarded by various political parties as unbiased and equitable, to require a supermajority for the selection of the ombudsman, to limit the political and many others action of the ombudsman, to eliminate the position from politics. Next is credibility in review process. When the ombudsman review process is reliable, people can more inclined to support the conclusions of their reports, and the government will more likely to adopt the ombudsman advice. As stated in the report of the Auditor General on the CHRC, consistent and established investigation criteria are important to ensure a reliable and equitable review process. The ombudsman capability to address issues will be sure once the office has reasonable investigation authority to collect the required facts, to evaluate the merits of the case, and to establish alternative for an effective remedy. However, the review must still be accurate with the entities being reviewed, where they must accept that they will be handled equally.
Thank you, Zerong. I will now continue on the applicability of Ombudsman in Malaysia. This discussion is made based on the earlier discussion on the characteristic of Ombudsman. Firstly, the applicability of Ombudsman to be implemented in our country is based on the fact that Ombudsman itself is an independent and bias-free office. This is in line with the principle of natural justice, in particular the principle of nemo judex in causa sua, which is the rule against bias. There would be, as it is independent, the investigation conducted by the Ombudsman Office would be free from interference of the government, which in some way, government interference would jeopardize the investigation. In the case of Datuk Sri Abu Bakar and others, and Indra P. Nalatambi and another appeal, it was stated by the court that an independent commission should be adopted to investigate public complaints in order to answer and query into the many unanswered questions in the complaints made. Secondly, Ombudsman is also applicable for the need to have confidence of the people to the government as the leader. Ombudsman, as discussed earlier, offer a credible review process due to the fact that the review is independent, bias-free, and confidential in nature. Complaints, when they are made, meant that there are possibility of maladministration occurred, which could then taint the confidence of the people to the government. Hence, when Ombudsman Office is enacted and query is made, the government then would be forced to work more diligently and more honesty in order to avoid any scrutiny from the Ombudsman Office and their credible review process. For the third practicability of Ombudsman is that an Ombudsman Office would ensure transparency in the government. With Ombudsman, they are able to have free access to the information and documents in the government without any limit. This ensures the government from hiding any information that is relevant in the investigation that would occur by any complaints. This also ensures that the government does not hide any information that would jeopardize the investigation that are made. Finally, it is also applicable for Ombudsman to be practiced in Malaysia, as it would bring more equitable justice to the complaints made. Any complaints made to the Ombudsman Office would be entertained on individual basis, which would make the complaints to be resolved quicker without having the need for the complainants to go to the court for any possible application of judicial review, which then would ease the burden of the court. In the case of Ketua Polis Negara and two others, and Noor Asmira Maulad and others, and another appeal, this case quoted from the earlier case of Datuk Sri Khalid Abu Bakar and others, and N. Indra Nalatambi and another on the need for an Ombudsman Office regarding justice. Whereby in this case, Ombudsman Commission is not merely needed for the compensation of any losses, but it is needed in order for the person where the complaints were directed to be more responsible and be accountable for their unlawful action as public officers. Before ensuring the applicability of ombudsman in Malaysia, there are two major issues that needed to be highlighted. The first one is there is a need for the amendment or the abolishment of the Official Secrets Act, because this act acts as a limitation for the Ombudsman Office to conduct an investigation based on documents of the government. Secondly, there is a need to enact a specific Ombudsman Act, whereby this act will enable the Ombudsman Office to be a functional body and having a conferred power by the Parliament to conduct investigation and management of public complaints in Malaysia. Although Malaysia does not officially have an Ombudsman Office, but it can be seen that in the establishment of Public Complaints Bureau and Ombudsman for Financial Service, that these two have traces of the Ombudsman principle that are being embedded in them. As for the conclusion, Ombudsman is a person who deals with complaints made by ordinary people against the government, bank and insurance companies. The purpose of utilizing the Ombudsman is to effectively control the activities of and prevent abuses by public officials after it came to be realized that the existing procedures and mechanisms were hardly adequate to achieve that purpose. In Britain, the Ombudsman concerned with injustice in consequence of maladministration in administrative action, which includes failure to act. The Ombudsman cannot investigate the matter relating to the dominant consideration of national or public interest, such as the matter concerning the extradition and the action taken in matter relating to contractual or other commercial transactions. In Malaysia, the Prime Minister dropped the establishment of Ombudsman system and changed with the Public Complaint Bureau. All in all, by performing this function, the PCB directly acts as the watchdog for the government against maladministration and administrative abuse. That is all from us. Thank you.